As a law professor and mediation expert, I often get asked, do both parties have to agree to mediation?
I say, bring it on.
And as a law professor and mediation expert, I find myself giving the kind of answers that law professors often give and that tend to drive students pretty crazy, namely, it depends. So if you stick around for just a bit more, I'll tell you what my answer depends on and give you 3 questions to answer when considering whether you'd want to participate in a mediation. So let me start with the basic question. Do both parties have to agree to mediation? The answer to this is yes, but with some caveats. In general, both parties need to agree to mediation. Indeed, part of the definition of mediation is that it is a voluntary process where both or all parties to the dispute work with a neutral third party, called a mediator, to resolve their dispute or conflict. A few years ago, I got a call from a CEO of a mid-sized company. We're interested in having you mediate a rough conflict involving one of our senior department heads and a number of his direct reports. We thought things were going well, but then learned through the grapevine that some of the folks on his team have been feeling bullied by him and some of his explosive behavior. After I asked a few questions, I started to learn that none of the employees wanted to participate in the mediation for various reasons, from being averse to conflict to fear of retaliation. Now, in a situation like this, actually a mediation can't move forward because you don't have both sides willing to participate. So then, what are the caveats? Well, in some situations, there might be a negotiated agreement, let's say between union and management, that requires both sides to try mediation even if they prefer not to. In some other situations, it might be the case that the union agreement requires the manager to participate in the mediation as long as the employee is willing to. There are other instances where an attempt at mediation might be required. For example, in some jurisdictions, parties might be required to participate in mediation in a divorce case before they can move on to family court. The issue of mandatory mediation is one that has been really hotly contested in my field. Some mediation experts think the notion of mandatory mediation is really an oxymoron. They would say that the whole idea of mediation is it's supposed to be voluntary. So by forcing parties to mediate, you're undermining part of what makes mediation so innovative and so valuable. Moreover, these experts would argue that to the degree mediation is supposed to be part of an effort to reduce court costs, forcing folks to mediate before they can have access to some kind of adjudication process ends up creating a more costly kind of click the box step that wastes time, wastes money, and ultimately ends up giving mediation a really bad name. So you might be thinking, well, what is the case for mandatory mediation in some cases? Well, those in favor of mandatory mediation would say that without mandatory mediation, many people just wouldn't try it. But once they try it, even if by coercion, a non-trivial number of people actually find it works, they find it successful. So the argument goes, it's worth forcing folks to at least make a good faith attempt at mediation before letting them move on to a more costly process. With these caveats in mind, it's otherwise fair to say that all parties to a mediation have to agree to participate. But as I said, there are a few exceptions. So then there's the second question. Are those who are parties to a mediation required to reach an agreement in the mediation? And the answer to this question is a decided no. Even in situations where participating in a mediation is required, under no circumstances is coming to an agreement required. Each party is always free to walk away from a mediation table. So with that background, how should you decide whether you might want to participate in a mediation if you find yourself in a dispute or a conflict? Here are a few questions to consider. First, what alternatives do you have if you choose not to mediate, and how well do those alternatives actually meet your interests? The decision to mediate should always be made in light of the other ways you might proceed absent a mediation and how well those other ways meet your short and your long-term interests. For example, one thing you might do is lump it or let the other side just have their way. Another thing you might do is quit. You might walk away from the job or the relationship or the opportunity. Both of these are examples of avoidance, which is a really common way that people use to handle conflict. In the coaching and the consulting work that I do, I often see folks choosing to lump it or avoid, and to be honest, this often breaks my heart to see. Why? Well, conflict is just part of life, and simply lumping it or leaving the situation rarely meets your deeper interests. All it really does is get you out of an uncomfortable situation. And my hope in the work that I do is for people to see that conflict, yes, is uncomfortable, but if you handle it well, it really can lead to improved relationships, sometimes to healing, often to innovation, and even sometimes to reconciliation. Now, that's not to say that you should never lump it or you should never avoid it. It's just to say it's a path that's too often and too easily taken without really good reasons. Now, of course, the other alternative you could pursue is to keep fighting. And this might be in the form of litigation, or maybe filing a formal complaint, or in the international arena, it could be imposing economic or trade sanctions. Again, if that is your alternative, always consider how well does this meet your deeper interests, not just the short-term goal of revenge or imposing punishment. Perhaps, of course, in your situation, there might be other alternatives as well. But whether you decide to participate in mediation shouldn't be a gut-driven decision. It should always be measured against how you will otherwise proceed and how that choice meets your full set of interests. Of course, as a mediator myself, I believe there are substantial advantages to mediation in many, many cases. Parties in a mediation have the ability to be creative about their own solution, rather than have one imposed on them. Instead of outcomes that just split the difference or create a winner and a loser, mediation often exposes a human side. It promotes understanding. It leads to more sustainable outcomes, and it's often quicker and less costly than litigation or other processes. There have been really many, many times, both on a grand scale and on a human scale, when I've been gratified by the power of mediation to really forge a favorable outcome. One of my first positive experiences as a mediator, and I still remember this well, occurred when I was a law student, serving as a small claims mediator in a local court. In this court, mediation was completely voluntary. So two parties came before me and my co-mediator, and the issue involved was an unpaid car repair bill. And the mediation did not start out well. It was quite acrimonious. The owner of the car repair shop had been assured by the owner of the car that the bill would be paid, quote, within the week. That happened for several weeks, and each week there was a new excuse. Now, the mechanic had taken an entire morning away from his work to bring this car owner to small claims court to get what he felt was his due. For his part, the car owner in the mediation said he intended to pay the bill. He restated in the most vague of terms all sorts of excuses for non-payment. The mechanic was having none of it. And then something miraculous happened. The car owner started to tear up. He said he was overcome with shame. He had recently lost his job, and his wife had been unwell, and the family was deeply in debt. He said he felt derelict and really sad for not being able to provide for his wife or his family or even pay his bills. He said that he couldn't even tell his wife about what was happening. He apparently told her he was going to look for day work and instead came to court and agreed to mediation. Upon hearing this, the mechanic's entire demeanor changed. I am so sorry to hear this story. It sounds like this has been an awful time for you and your family. Yes, replied the car owner. Why didn't you tell me this instead of continuing to promise you'd be paying me every week? The car owner just said, I feel tremendous shame. And with tears in his eyes, he said, I have failed everybody and can't even pay my bills now. To our great surprise as mediators, the mechanic said, let's cancel this bill. I'm glad that I was able to repair the car for you. And for me, I'm here because actually I just felt disrespected. Of course, I need payment for my work. But my main reason for pursuing this wasn't really the money. It was for pride. And I understand that pride is also what made it hard for you to tell the story you just did. Now, I appreciate this sounds like a Hallmark movie, but honestly, it was real. And it made me see that mediation at times can have advantages that other processes just don't have. Now, of course, not every or even most mediations go quite like this. But mediation has possibilities. And as you weigh choices, keep in mind the power that a mediation has to hatch outcomes you just didn't expect. In this case, I truly believe that both the car owner and the mechanic were better off after the mediation than before, even if the law might have been wholly on the side of the mechanic had he pursued the action. What started in acrimony ended in a heartfelt handshake and a release of obligations. Second, if you decide mediation might be a good way forward, choose a mediator wisely. In most jurisdictions, mediators who are not court-connected are unregulated, and even if they are regulated, mediators have wildly different styles and approaches. For example, some mediators see their main role as hashing out an agreement, even if that means being highly evaluative and forceful. For example, in the legal world, many times mediators are hired because they're seen as having a great deal of experience in evaluating a case, maybe because they served as a judge in the past or because they're an expert in a particular legal practice area. Other mediators may focus more on relationship dynamics between the parties, so they might be more facilitative and less likely to evaluate the merits of the case. They might instead invite parties to examine how underlying interests and relationship dynamics might be contributing to the conflict, and then they might help parties brainstorm solutions. My own approach, my own background and preference is toward this relational approach that examines both the substantive issues in conflict, but also the dynamics of relationships and emotions and histories that can contribute to deadlock and possible resolution. Now, you might not always have control over who the mediator is in a particular situation, and when you don't have control, it's still worth doing some research to understand what their background and their approach is as you consider if you want to participate in the mediation. Finally, ask yourself, if I choose mediation, And if it doesn't reach an agreement, how does that change what alternatives might be available to me? In some cases, the mediation process might alter the landscape of possible post-mediation choices for you. Consider a situation where you are in a conflict with a colleague at work. You may be choosing between trying to work it out through a series of one-on-one conversations. If they don't work, you can then decide to just suck it up and continue your collaboration with your annoying colleague or ask to be transferred to another team. However, if you ask for a mediator and things don't work out, you might think it will simply be too awkward to suck it up and continue to be on the team. In that case, one of your alternatives might feel as if it has disappeared or become less palatable. Perhaps it's worth the risk, perhaps it isn't. But it is important for you to consider these questions before you decide whether to mediate. So, mediation is a process that is highly favorable because the parties involved can decide whether to participate in almost all cases. Even in those situations where they're compelled to participate, they are never forced to reach an agreement. Now that you know more about mediation, I want to direct you to this video, which is what are the qualities of a good mediator. Thanks for hanging out with me. Don't forget to like, subscribe, and hit the bell so you don't miss out on any other content. And of course, if you want to learn more about mediation, what mediators do, and how to become a mediator, keep watching these videos. And if you need mediation services, I hope you'll reach out to me at bobbordone.com. I'm Bob Bordone. Let's keep negotiating together. Click the next video. Here it comes. What makes a good mediator? You are only one click away.